Today we're talking about the Violence Intervention Ambassador Project, presented by Impacting Communities, Operation Springboard, and OGEN. To my left, I got Roger Shallow in the house. He's a Crown Counsel. Roger, how you doing?
I'm fantastic, Roger. How are you?
I'm good, thank you. And then to my right-hand side, I got Officer Ferguson. Officer, how are you?
Yay.
You ever hear an officer say that to you before, Malika?
No.
You see him driving down the street, just be like, yay.
No.
What would you do? Just freak out? No? You wouldn't freak out on that? I would go nuts. We have to find out a little bit about these young men. So can I do a quick thing for you? Roger, tell us a little bit about being a Crown Counsel and what exactly is that?
Okay, Crown Counsel, I'm a prosecutor. I think you'd be familiar with that term. And so in the criminal justice system, you have defense lawyers who will defend persons accused of crimes, and you have prosecutors or a Crown Counsel. And that's what I do, in a nutshell.
All right, and so Mr. Officer Ferguson, now, don't tell me that you're an officer, because I know what officers do. But exactly, what is your role?
Presently, my role is in recruiting.
Okay.
And I go out and try to recruit individuals to become police officers. And one of the reasons why I went into recruiting, I've worked in this community in the past, and many of these youth today actually know me from the school, because I used to be a school liaison officer.
Now, I'm going to be honest with you. I don't know if I'm a youth, if I want to be an officer, based on you coming to me and wanting to recruit me. Why would I want to be an officer?
Well, for me, I try to make it so that they believe that the policing is a viable option for them.
Okay.
You know, so that's why I try to bring to the community that it's a viable option for them in the future.
We are at the round table here, speaking with youth with amazing questions from the Violence Intervention Ambassador Project. We're sitting here with Aisha. Your question.
Do you always feel justice is served at the end of every case?
No. That doesn't mean that the trial itself wasn't fair and the process didn't work the way it was supposed to. Let me explain. There could be a situation in which factually we know that a certain accused person is guilty. And we know that because we have a confession from that accused person. And that confession led to the discovery of physical evidence linking that offender or accused person to the crime. But because of a charter violation, for example, let's say a failure of the officer to advise that accused person of his rights to counsel, that confession and the evidence that came from it is now excluded from the trial. Okay? I would feel, in a sense, justice wasn't served, especially having regard to the victims of that crime. But the reality is, these rules and these charter protections and rights that we all are afforded are there for a reason, to keep the system in check and to keep things balanced. And so, while I might feel personally that justice wasn't served because that person is factually guilty, one of the cornerstones of our system is based on the notion that it's better 10 guilty people go free than one innocent person go to jail.
Yes, dear. When you win a case, do you get paid more or less?
I wish as a Crown I got paid for performance, but the sad truth is, well, not even the sad truth, the reality is we don't. And there's a reason for that.
So even when you lose a case, they don't take no money from you?
They don't, and for those of you that were here last week, what's the answer to that question? Why is that the case? Who does the Crown represent?
The people.
The people, as do the police officers as well, right? We represent the public, which includes even the person who's being charged with the offense, right? And so on that basis, it would seem rather contradictory to, reward the Crown for success in a prosecution, because we don't win or lose, right? We're all involved in a search for justice and for truth, right? And so if the evidence as presented in a fair manner results in a verdict of not guilty, well, as long as the trial was a fair trial, well, then justice was served in that situation. Because the Crown has to prove a person's guilt beyond a reasonable doubt.
We're sitting here with Natasha. You have a question for Officer Ferguson.
The question I wanted to ask today is, do our charges drop by 18 years old?
So I'm going to say that you're asking if someone is convicted when they're a youth, when they become 18, do that charge gets dropped. The lawyer probably can answer that better, but from my perspective and how we're taught is that, I'm going to answer from a police perspective. Those charges are still available to us in certain circumstances. The charges don't get dropped. They should be expunged from the record, wherein when you're an adult, that youth record should not follow you into adulthood. However, on certain checks, we do have access to those records. It can be sealed, but you should be able to speak to your lawyer to get that off the book where your fingerprints can be removed, etc. But it all depends. But technically, it's never dropped. It's always going to be there to some extent. So whether it's sealed or not, we still have access to it. We may have to apply to get it on some circumstances. But even though the record may not be there, we still have reports of it. So it's a loaded one where it's all depends.
If somebody was in jail and they were like found not guilty and then they can just come out, so like what happens to that person? Like they just walk out with being spent in jail and to find out that they're not guilty, like they just walk out of jail and you know?
So in that situation, the person's already been found guilty, their appellate lawyers bring appeals to a higher court, and if they're successful, the person who's in jail, depending on what the outcome is, the Court of Appeal can either vacate the conviction and order an acquittal, which means not guilty, right? In which case, theoretically, the person steps out of custody as soon as possible, right? The other alternative is the Court of Appeal says, you know, the trial was not fair, or but for this evidence, things might have been different, and so vacate the conviction and order a new trial, right? In which case, the person doesn't get to step out of jail right away. It's the equivalent as though he was just arrested and charged with an offense, and so he'd have to apply for bail pending his retrial. And his lawyers will go through steps to try and secure his release before the retrial is heard. And in some cases, depending on the strength of this new evidence, even though the Court of Appeal might order a retrial, the Crown may consider ultimately that it's not in the public interest to actually do a retrial for any variety of reasons, in which case the person is then, you know, free to go.
Can the appellate court award damages right there one time, or does that have to go through a civil proceeding?
No, it's the latter option, right? So the criminal appeal court only deals with the criminal trial itself.
Right, so any damages and everything always has to go through civil.
That's right. In a unique scenario, a criminal court can award cost against the Crown. But that's a unique circumstance where the Crown was proven to have engaged in bad faith and high-handed malicious prosecution itself. And so in that circumstance, if the defense lawyer leads the appropriate evidence to establish that, then a court can award cost against the Crown, which is separate and apart from civil damages. It's more so for the cost you had to incur to defend yourself in that proceeding, right?
How you doing, buddy?
I'm good. How are you, Roger?
I'm always good. And now you're part of the Violence Intervention Ambassador Project. We're sitting here interviewing both Roger and Officer Ferguson. You've got a question. Feel free to ask.
Well, my question is for Officer Ferguson. I wanted to know, faced with this a couple months back, maybe a year, and it was from then I've been wanting to ask this question, so here it goes. My question for you would be, if faced with an unfair officer, how would I go about it and who would I report to?
All right, so if you're faced with an unfair officer that's treating you poorly, things that you can note is name. We have name on our right chest. We also have badge numbers on our shoulders. Feeling that there's also vehicles that we drive that have a car number on it. What you do is the nearest police station to you, you go in there and ask for the officer in charge of the station. Once the officer in charge of the station is there, you can then make your report to the officer in charge at the station. And if you're not satisfied with the response from there, then you can ask the officer in charge of the station, I'm not satisfied with this, I would like to take it further. And then he's by law bound to give you the agency by which you can go to take it further.
Okay.
Is there something perhaps a bit intimidating or counterintuitive about a young kid who feels he's not being treated fairly by a police officer to go to that police officer's station to report to that police officer's, colleague or boss?
It can be intimidating, but in that situation, I'd suggest perhaps maybe take someone with you in that regards, an adult, if so be it, whether it's parents or some kind of social agency.
Is there an independent agency not connected specifically to that police station? For example, we've heard about the Office of the Independent Police Review Directorate, right?
There is that option available, and and that's what I'm saying. Generally, if you're not satisfied, because sometimes you try to go direct where the officer itself is directly impacted. So if you go direct that way, and then that's what I'm saying. If you're then not satisfied with that, because sometimes officers at the station, they don't want the officers out there to be bringing disrepute to the service.
Right.
So they want the opportunity to make that correction themselves, to say, you know what, we want to show you in good faith that you can trust us and that, this service can work for you. Because if we're not satisfying the community, then we're not doing our job.
I'm sitting here with Crystal. You've got some questions for both these gentlemen, don't you?
Yes, I do.
Feel free to go ahead.
Okay, so my first question is for Milton. Can a police police a police?
Ooh, I like
To
that.
answer that, no. If I'm going to be straight up. To some extent, yes, we can to some degree, but you want there to be fairness and don't want to see anything to seem to be that there's some impartiality in respect to that. So in that case, I don't think the police should police the police.
Crystal, would you like to see the police hold each other accountable?
I would say yeah,
Okay.
in a way, because during a police officer paroling, there's two partners working together. So basically, they have to oblige with each other due to what they're doing.
Right.
In that sense, yes, we can police each other, because I've been in a situation, and I mentioned that yesterday, that wherein one of my colleagues who I felt was not acting in the proper manner and took that officer aside and addressed the issue. So to some degree, we can police each other in those extent. But if it gets beyond a certain level, then sometimes we have to then step back so that the public don't perceive an impartiality in respect to that.
Right. So I guess in a nutshell, what you're saying, there's certain degrees of conduct, and conduct falling at the lower end perhaps can be dealt with in-house
Yes.
versus things that border on being criminal now or involving bodily harm should be investigated by an outside
Yes,
agency.
independent sources.
Wow,
And-
Crystal's coming here and just asked a question again. Everybody all jumping around here because I'm dying to follow up with this here, but I know you have another question, don't you?
Okay, due to wrongful conviction, what are the process for the victim who's being wrongfully convicted? Like, what are his process to go ahead to prove his innocence towards the court and the public?
Okay. So a person has been accused of committing an offense and had a trial. And as I said earlier in the show, the Crown has the obligation of proving a person guilty beyond a reasonable doubt. That's a very high standard. There are cases where years after a person might have been found guilty, new technology or new evidence becomes available, like DNA evidence, for example. We've heard of cases like the Truscott case or Guy Paul
Yes.
Moran. Hurricane Reuben Carter is another example where
Exactly.
years afterwards, new evidence exonerates that person. In that circumstance, there are procedures set out in the criminal code to bring that matter back before the court or before the Attorney General to have a relook at it. In circumstances where it's established that the evidence would have affected the result or exonerated that person, the right thing will be done. Having said that, how does this person get back all that time, right? In some situations, the government will voluntarily enter into negotiations to compensate that person for all that time, depending on the circumstances. In other scenarios, the person will have to bring a civil suit to try and sue either the police force or the prosecutor for malicious prosecution or negligent investigation.
You know what, Rod? The second half of our question is probably more important than the first piece because it's about exonerating yourself in the public. So the public has now taken on this role, or the media's taken on this role of persecuting an individual. But now this person's found not guilty or even wrongful conviction. And there's really no role from, I guess, the media or even the police to say, we are now going to take a front page ad out and say that this individual is not that person. And so they're left in the public's eye of going, they're still guilty. And now they have to walk around spending X amount of dollars trying to prove themselves.
Exactly. So, for example, in the Truscott case, when he was released, but in the eyes of the law, he wasn't innocent, but he was basically, there wasn't enough evidence to prove his innocence. But then in the public's eyes, he was still a murderer because he murdered Lynn Harper. So in that case, what about the public? Like, what would the law,
What can be done for that?
Yeah.
That's
Okay.
a great question, by the way.
It's a very good question, and it raises an interesting issue, because I believe it was a Truscott case where his lawyer on appeal, James Lockyer, tried to actually get the Court of Appeal to declare that he was innocent, to sort of take away this stain that was created by the allegation, the conviction, and the number of years he was in jail. But the reality is, there's no such verdict as a verdict of innocent. A verdict in a criminal trial can be either not guilty or guilty, or not guilty by reason of not criminally responsible, rather, right? There's no verdict of innocent. And so, the only recourse for someone in that kind of a position would be to, get the conviction overturned, and he's acquitted. And so therefore, he's no longer a convicted murderer, as in this case. But to take away the impression that might be left with, for example, the victims of that deceased person, you're not going to change their minds based on what happened in court.
Well, I'm your host, Roger T., sitting here with my co-host, Crystal. Great questions. We're here with the Violent Intervention Ambassadors Project with both Roger Shallow and Officer Ferguson.